Good morning and welcome to our company law class. So this morning we want to continue with a new topic, the formalities of corporate incorporation and related matters. Uh, in this lecture, we will be exploring matters relating to formation and registration of companies, the right to form a company, formalities and application for incorporation, the option to apply for incorporation with the proposed constitution, the power of the registrar to decline an application for incorporation, and then we will discuss the crucial topic, incorporation and corporate personality, the consequences of incorporation, lifting of the veil of incorporation, and then we will touch on company names, although we've talked about it in the course of our last lecture, and we're providing some of the explanations. So that is the roadmap of what we will be exploring in this lecture. Yeah, so in our last lecture, we discussed the incorporated company, and we did make the point that to acquire the vehicle we call the incorporated company, you must follow certain prescribed requirements and procedures. When you have done that, then you'll be issued with a certificate marking the fact that you have now acquired a vehicle known as an incorporated company, which you can use to do business. Now, every person has a right to work or undertake a business as a fundamental economic right, and that one is beyond dispute. So you must work, either you are working for somebody as an employee, or you are working for yourself, or you join forces with others to set up something. And for that matter, the law, in terms of Section 6 of the Companies Act 2019, Act 992, guarantees the right of one or more persons to form an incorporated company. So one person, you can own a company, be 100% shareholder, or you can get other people to join forces with you, as it were. Now, who qualifies to apply for registration of a company? A person of 18 years and above qualifies to apply for incorporation under the Companies Act. And this is provided for in section 12 of Act 992. And it is pertinent to appreciate that unlike the old law, the repealed Companies Act 1963 at 179, which stipulated that to be a subscriber, and for that matter, someone who is interested in applying for registration of a company, you have to be 21 years or more. It's no longer the law. Now it's been reduced to 18 years. Again, it is important to remember that a company or an association of more than 20 members cannot do business for profit unless it has been registered under the Companies Act or any other designated act. And this is important because of what we learned about incorporated private partnership, where the maximum number is put at 20. I mean, yeah. So if you have more than 20 and you want to do business for profit, then you must necessarily register under the Companies Act or other designated act. And that is what Section 3 of the Companies Act 2019 Act 992 tells us. So it is mandatory for you to now take steps to acquire the incorporated company vehicle. So let's keep that in mind. So what must one do in order to get incorporated company? An application must be submitted to the Registrar of Companies in the manner prescribed by Act 992. An application may be accompanied by a constitution or without a constitution. And we have to look at the Section 13, which provides the procedures, the mechanics of incorporation. Now, Section 13.1 provides that an application for incorporation shall be made in the prescribed form and delivered to the registrar. So, the prescribed form means that you have to go to the Registrar of Companies and buy the requisite documents, the forms, which you complete. And now it's even available online. So I think the Office of the Registrar of Companies has a website. So just before we continue, I would like to take you to the website if it's active. So this is the website. So Office of Registrar of Companies, orc.gov.gh. So that is the website. So if you go there, this is the home page. The services, they have a search here. Very soon we'll be talking about name. The name, for example, the name that you are interested in actually using for the company, you do a search to try and find out if it's available. So let's see if it will work. We haven't although registered, but maybe let's get the I think they want, they want to force you to register before you can. You create an account. You create an account and then you register and you'll be able to use their services. But let's see they have the public companies bulletin through which they put information concerning the companies. So this is like a very useful. Then what I'm interested in, like the forms. Good. So if you want to um, you want to register company, let's say with shares, okay? Company with shares. You notice that they have like the form, you can just download. So if you want to do private limited company, right? Company limited but where is private? Let's say you click here, you download it. So oh, yeah, so you download it and so you see, so this is the form. Let's see. Okay, what does it say? Okay, so this is the application to register a company with shares. Okay, so you download this and the name which you would like to have for your company, and then we are told that the endings limit LTD or this one should be there. The name of the subscriber, the person applying, then your tax identification number, your TIN number, your details, and then the category. They want you to indicate the sector within which the company that you want to establish falls. Is your company in the legal sector? Is it in the estate housing, media, tourism, hospitality, sanitation, or what? You're supposed to indicate that. And then if you have the ISIC classification code, that is a standard classification of economic or business activities, so that establishment could be classified based on activity they carry out. You provide the ISIC code over there. Then the nature of the business. Maybe what business are you going to do? If you are specialized in switching, for example, you are going to do banking, insurance, or any of the security companies, you must indicate. But if you are none of those, it's not mandatory, although you can provide it. So the registered office address, the digital address is even now required because you have the Ghana Post digital address. the locational address, house number, address, the district, and so on. Then, apart from the registered office address, principal place of business, because the registered office address may not necessarily be uh, the principal place of business. Now, in terms of section 13, 2, D of Act 992, it is a requirement for every company to have registered office, and it is the address to which the Registrar of Companies may send correspondence. Now, later on, when we are discussing winding up liquidation, you will notice that we have dissolution without winding up, where a company has become more or less a moribund, non-functional. The registrar may send a correspondent to the registered address. If after a prescribed period, the registrar does not get any reply, the registrar will repeat it, do it about 2 or 3 times. And if no reply comes, then the registrar will go ahead and strike off the name of that company from the list of registered companies. And that is why the registered office is very important. You may be doing business in different places, that is fine. So you have to have one principal place of business and other places of business as well, as the form indicates. Again, you're also supposed to indicate the address at which register of members will be kept and maintained. If the register of members will be kept at a place other than the registered office. So register of members are a document in which anybody who is interested will go and find out how many people have become members, who is a member, who has how many shares, and so on. You can go and do inspection. Sometimes it may be kept at the registered office, or may have a designated place in which that may be kept. If that is the case, then you are supposed to indicate that in the application form. And of course, your postal address and also contact of the company, phone numbers, mobile phone, fax, email, and then website. Particulars of directors. Particulars of directors are supposed to be provided, and again under Act 992, a director should be at least 18 years and above. So once the person is 18 years and above, he can be a director. Now, directors are required to depose or swear to statutory declaration concerning matters required of them under the law in terms of Section 13 and Section 172, subsection 2 of Act 992. Now, statutory declaration is a solemn statement made under oath according to the prescribed form by the Statutory Declarations Act. You have a law called the Statutory Declarations Act, and that law says that where you have made no solemn statement under oath, you are saying that what you have said, it is accurate, it is true. So therefore, should it turn out to be untrue, then you have created a legal problem for yourself. You could be open up for perjury or for some other offenses. So it's a very serious thing, and that is why we take statutory declaration content serious, because the accuracy of the content is guaranteed by the law on the pain of punishment if it turns out to be untrue. So, what are the matters which the directors that have been nominated at the start of the company are supposed to state in the declaration? That the person within the preceding 5 years of the application for incorporation has been a director or a senior manager of a company that has not been a director. Okay, you are saying that within 5 years before the application for incorporation, you have not been a director or a senior manager of a company that has become insolvent. If you were a director or a senior manager of a company which has become insolvent, then you don't qualify to be a director of a new company to be registered. So you have to take that. Then you also have to indicate that uh, whether you have been convicted of criminal offense involving fraud or dishonesty. Now, previously, you remember the case of Derek Edujamfi versus the Attorney General, where the Supreme Court upheld the argument that the provisions of Section 13172, which, among other things, stated that where a person has been charged with an offense involving fraud or dishonesty and so on, then automatically the person was disqualified. And mind you, in terms of Article 19 of the Constitution, we have presumption of innocence. Where you are charged with an offense, it does not automatically mean that you are guilty. You have to be taken through due process and for your guilt to be established beyond reasonable doubt before a court of competent jurisdiction can pronounce that you are guilty and you are convicted. And for that matter, the Supreme Court finds it unconstitutional for a provision which says that if you have been charged with an offense of fraud or involving dishonesty and so on, then you don't qualify to be a director. It should rather be if you have been convicted. And that is why the Registrar of Companies have also amended their forms. And now they simply say that indicate whether you be convicted of a criminal offense involving fraud or dishonesty, or convicted of a criminal offense relating to the promotion, incorporation, or management of a company that has become insolvent. Now, if you take yes to any of those things, you are supposed to provide the details. You are supposed to provide the details. Then you must also provide the consent consent letter, a letter that yes, you've consented to being a director. So all the directors will have to do that. But although this form has been provided, in terms of the statutory declaration, it was still a separate statutory declaration, in my view, will still have to be attached to the form because a statutory declaration has a prescribed format under the Statutory Declarations Act. And for that matter, the form will not satisfy the requirement that if you are going to be a director, you must actually accompany the application for incorporation with a statutory declaration. And just let's do what lawyers or people of the law we know how to do best. So somebody should just read section 13 H. Section 13H. I'm sorry, section 13, subsection 2, paragraph H. Who will read for us? Anybody, just go ahead. Akuya Sewa, read for us. Yes. Or anybody who is ready. Anybody who is ready can read for us.
Sir, this Reverend Cancer.
All right, Reverend, please.
Yeah, so section 13, as under application for incorporation. And so section 2, the application shall include the name of the company as required by
Please jump to the H.
the H.
Yes.
Thank you, sir. So section 13, section 2, H. A statutory declaration
No,
by...
so you start from, read the preamble, the chapeau. Start from the 2 and then we jump to the H.
Start from the 2.
Yes.
The application shall include...
Then you jump to the H, yes.
Then H. Shall include a statutory declaration by each proposed director of the proposed company indicating that within the preceding 5 years, that proposed director has not been charged with or convicted of a criminal offense involving fraud or dishonesty. Charged with or convicted of a criminal offense relating to the promotion, incorporation, or management of a company, or III, declared insolvent, or if that proposed director has been insolvent, the date of the insolvency and the particulars of that company. So that is it for the H.
Okay, thank you. Now, the word statutory declaration has been used in the section 13, subsection 2, paragraph H. So we need to understand what the lawmaker means by statutory declarations, so that we know what is required. So let's go to the first schedule and look up if we can find the word statutory declaration over there. Yes, please tell me. Is it there? Have you seen statutory declaration there? If it's there, tell me. If it's not there, tell me. Hello, are we together?
Let's see.
Is it there? Or it's not there? If it's not there, tell me. If it's there, tell me. It's not there, but you're afraid to tell me it's not there. It's not there. It's not there. Yeah, and that is why I've taken you here. Just trying to teach you something. So let's see. So I've come to Danish law, and I want to look at what you call the Statutory Declarations Act. Okay. So So this is the Statutory Declarations Act, 1971, Act 389. And it provides, and now to provide for the making of statutory declaration for related matters. So what this means, to my mind, is that as far as Ghana is concerned, whenever a statutory declaration is required to be done, unless another law has provided a unique way in which it should be done for that particular purposes. Otherwise, the default framework or the default way of doing it is what we have under Act 389. And for that matter, if you look at Section 13, subsection 2, paragraph H of the Companies Act 2019 Act 992, requiring that a person who has been appointed a director for the company which is yet to be formed must provide statutory declaration, providing those information that has not been convicted of the offenses indicated and all that. That statutory declaration should be according to what Act 389 tells us, because if you go to the interpretation section of the Companies Act, the first schedule, we didn't even see statutory declaration there, meaning that the lawmaker has not intended any particular or a unique meaning of statutory declaration. If the lawmaker wanted us to understand statutory declaration in a very unique way for purposes of what was being provided in Section 13, the lawmaker will have told us so, at least in the interpretation section of the first schedule, but it's not there. So therefore, we fall on what the general position of the law is. And the general position of the law is what we have in Act 389. So that's what I wanted you to know. If you look at Act 389, yes, we are learning. So let's quickly look at this. Look, at a commencement of this act, section 1, an affidavit shall not be sworn for a purpose, except A, where it relates to a proceeding, an application, or any other matter commenced in a court, referable to a court, or B, where under an enactment an affidavit is authorized to be sworn. So, section 1 of the Statutory Declarations Act 1971, Act 389 is telling us that where there's a case before a court or something is likely to go before the court, that is where you need please put your mic off. Put your mic off.
That's an insult.
Please learn this basic courtesy. When you are doing online class, apart from your lecture, you must always have your mic off. So learn this. Yeah, so it is the law, as we have seen in section 1, that and I want you to get the distinction, okay? Get this thing clear in your mind before you even get to the law school. And a lot of people confuse the use of affidavit and statutory declaration. Affidavit is a sworn statement used in matters pending before court or some adjudicating fora. Where it is not in respect of a pending matter or matter to go to adjudication, you need to do statutory declaration. So in terms of functions, statutory declaration are sworn statements not necessarily used for court proceedings or court-related proceedings. An affidavit is a sworn statement used strictly for court proceedings or court-related proceedings. So don't let us forget that. So statutory declaration, as you notice, can be used for many things. So section 2 will tell us what it is used for. That where section 1 does not apply, that's where it's not about court proceedings or court-related proceedings. If a person wishing to depose to a fact for a purpose may do so by means of a statutory declaration. If you want to make a statement and you want everybody to believe that you are telling the truth, you do that by statutory declaration. Now, where a person has sworn to an affidavit for a purpose other than the purpose referred to in section 1, affidavit is never delayed for all purposes a statutory declaration. So, if you even don't use the word statutory declaration, okay, and you've done affidavit in respect of something, and the affidavit is not really related to any court proceedings, section 2 is saying that despite the fact that you use the word affidavit, to all intent and purposes, it is a statutory declaration. So that is the import of section 2.2 of the Act 389. So let's keep that in mind. But let's look at the form, how statutory declaration is done. And it's very simple. This is the format. You provide your name. And there's also the power of Kuntanase, house number 1. So and so solemnly and sincerely declare that I come from Kuntanase. My parents come from Kuntanase. I have not been convicted of fraud. And I make this solemn declaration, conscientiously believing it to be true in accordance with the statutory declaration of 1971. So I have finished statutory declaration. That is it. Now, the very important aspect is section 5, offense. A person who makes, but then, okay, let's also add this, the procedure for making it. You have to make the statutory declaration before a magistrate, a notary public, commissioner for oath, or any other person authorized by law to administer an oath, may take and receive statutory declaration of a person, voluntarily making it. And if you are the person before whom the statutory declaration was made, you have to actually certify that it was before you. Now, a person who makes a statutory declaration knowing it to be false in material particular, or who makes a declaration which is false in a material particular or reckless, whether it is true or not, commits a misdemeanor. So if you have made a statement in statutory declaration, and if we can demonstrate that you need to be false, or you're reckless as whether it was true or not, you have committed an offense and you can go to prison at least for some few months. So let's keep that in mind. Yeah, so you have to provide all this information as we just discuss. And of course, the company secretary, you must also provide the information of who's going to be like the company secretary. The auditor of the company must also be provided. And you must have a consent letter from auditor of the company. Interestingly, a lot of people who would like to register a company They don't have auditors. So some of the staff at the registrar of companies, they have arrangement with some audit firms. When you go, they make some available to you, and then you pay money, and they agree to be your auditor. They give you the consent letter. You must also provide details of shares and stated capital. So if the company limited by shares, how many shares is the company being registered with? So how much has been paid for some of the shares? Now, since the company limited by shares, at least uh, each of the subscribers should have at least one share, as it were. And then the structure of the shares, we have, later we come and discuss corporate finance, but just to let you have a feel of how the application for incorporation looks like. Then this session must be filled with or without a registered constitution. Yeah, so those who are interested, who have agreed to become a member of the company by taking up shares at the inception of the company, they are called subscribers. So you will actually submit the application, as it were, by signing the duly completed application for incorporation along the manner that we'll be looking at. Or you sign the duly completed application for incorporation to this form and the constitution of the proposed company. It's not mandatory for you to have a constitution, but if you choose to have a constitution, then that should be submitted together with the application. The subscribers should be minimum of two. They can be more, but at least there should be a minimum of two subscribers, those who are submitting like the application. The subscriber can also be a body corporate. A company can also apply for a company to be incorporated, so that is also possible. And then the officers or the directors, either a director and a secretary, are supposed to sign their signature together with a seal or stamp of the company. Or you can have two directors if you don't have a stamp or seal. Two directors plus the company secretary will sign, and that will suffice. But then if you have a stamp or seal, then one director and the company secretary, that will suffice. They've also made a provision where maybe shares are going to be created in trust for minors, people who are below the age of 18. You want to give them shares, or so maybe an individual can hold the shares for a minor, or a corporate body can hold the share for a minor. All that will have to be indicated in the application form. Yeah, so on your own, I would like you to go to the uh, website of Registrar of Companies, download the forms and look at some of them. As I've told you, we are learning company law, in substance and also practice. My company law students who take me serious, when they go to the law school, they don't suffer at all. So learn it well. Then there's also what we call the beneficial ownership. So later we'll be discussing section 35, subsection 14, and subsection 15. So a beneficial owner will be told is the individual or natural person who owns, controls, or has interest in or exercise influence over the legal person arrangement or receives substantial benefit from the applicant's activity. So beneficial owner is an individual and cannot be a company. So it may be that you are the rare person who is going to benefit from the shares. but you are using somebody as a front. So as part of fighting corruption, money laundering, and all that, our new Companies Act, Act 992, has introduced this concept of beneficial ownership so that no one can actually be a front for another person. Someone who does not even earn income of, let's say, 5,000 cedis, or for example, have about 1 million cedis worth of shares in a company. Certainly, that should tell you that he is just being a front or an agent for a rare person hiding somewhere. And that rare person might have stolen the money or the money must have been like a process of a crime. So we want to guard against all that. And that is why the law says that there should be full disclosure of beneficial ownership. And we are told who a beneficial owner is. So let's keep that in mind. Yeah, so when you have done all this and you submit, the rest will be for the Registrar of Companies to actually determine whether you have done what the law requires you to be done. And for that matter, you should approve the application. Because we look at the form, we discussed all this already, so let's skip them. Now, we have to also remember that specialized companies, that is companies which are doing business like banking, insurance, or securities. When I say security, I'm not talking about the securities as in the police and the soldiers. No, I'm talking about securities as an instrument of investments, as it were. The the brokers and so on. But so for those special companies, as we have noted, they have their own unique legislation and there are additional requirements which they have to fulfill. And I ask, will past performance of the requirements under Section 13(2) suffice or be enough for incorporation by the registrar? In other words, if you have done only some of the things, can the registrar ignore the rest and say that you have met the requirement and issue you the certificate of incorporation? Yes, what do you think? Maybe somebody did not provide the email address, did not provide a telephone number. Can that be ignored and then the certificate of incorporation issued? Yes, what do you think? One person at a time. You can raise up your hand.
No, my lord.
Why? Why? Explain.
My
Yes.
lord.
Yes. Is it Kim Paul speaking or?
Yeah, I'm the one speaking, my lord.
Okay.
My lord, I think that every requirement that has been stated there has one way or the other a very important role to play. A situation where you are unable to complete the form, you've done half and perhaps you've left some of them. I don't think it is very appropriate that it should be considered. So I don't think it
My lord.
is sufficient.
All right, thank you.
Yes, sir.
Yes, who is, please, I will prefer that when you come to the online class, you use your real name so that I can know you. Who is my joy? Somebody's hand is up. It's called my joy. You can speak, but let me know who you are, okay? Yes, my joy, go ahead. Well, regarding the question that I asked, whether part performance will still justify the registrar approving registration, I would like you to look at section 13 and look at the operative word. It said shall, and shall means mandatory if you look at the Interpretation Act. So, but the de minimis principle that the law is not about trifles will also come in. So let's suppose that a person does not have a telephone contact, but he has a postal address and email address. Will not having a telephone number be a reason for refusing his incorporation? Well, I don't think so, but it's subject to debate and formal judicial pronouncement, and there is none yet. Now, let's look at the other related issue. The option to apply for incorporation with a proposed constitution. When we went to the Office of Registrar of Companies website, on the form, we saw that you can apply for registration without any proposed constitution or with a proposed constitution. And in fact, that is made possible by section 13, 5B, as well as section 23, 1 of Act 992. So where a proposed company opts for a constitution, as we saw on the form for the application for incorporation shall be signed by the subscribers for shares of the company by writing opposite the name of the subscriber the number of the shares the subscriber takes and the cash price payable for the shares, and the subscriber shall take at least one share. So that is effect of section 13, 3, and 4 of Act 992, which we have looked at how it works out in practice by going through the form, so we will not belabor the point. And it is equally important to note that by virtue of section 13(6) of Act 992, an applicant for incorporation must furnish the registrar with appropriate evidence of his or her identity. So now that we have the Ghana card, your Ghana card will be required. That is official proof of your identity. And the place of residence at the time of the delivery of the completed application form for incorporation will also have to be disclosed. Has the Registrar of Companies got any power to refuse or decline an application for incorporation? The answer is yes. An submission of application for incorporation does not automatically birth or bring into existence the proposed company as a body corporate. So, the Registrar of Companies is supposed to require applications. However, the Registrar of Company is not obligated to honor all applications for incorporation, because the Registrar of Companies must certify itself that the requirements of the law have been satisfied. And what are the requirements of the law? So, as a general rule, where the registrar is not satisfied that an application has been made properly or in the lawful manner, the registrar may deny the application for incorporation. But then, where the right thing has been done and the person has done all that is lawful and the document is in order, the registrar does not have any power to refuse an application for incorporation. And it is useful to look at the English cases of R against Registrar of Companies, ex parte Bowen. Now, before I move on, interestingly, here in Ghana, because of the Fama Nyame aspect of our life, of course, it's good not to be fighting, but for purposes of law development, Fama Nyame does not help. You have to go to court so that our jurisprudence will be enriched. When people go to, let's say, Register of Companies to apply for incorporation and they are denied, instead of, for example, taking it up and fighting it in the court for the court to make a determination as to who is right and who is wrong, they'll just leave the matter there. So that way, we don't get jurisprudence to actually illuminate some of these aspects of our law. But in English company law, there are a few decisions regarding the power of the registrar to refuse or to approve application for incorporation. So we have the case of R against the Registrar of Companies, ex parte Bowen. An English case, as I have told you. And in that case, application was made to register a proposed company named the United Dental Service. The United Dental Service Limited. The subscribers to the memorandum were 7 unregistered dental practitioners. The Registrar of Companies refused to register the company unless either the memorandum was altered so as to provide that the work of the company should be undertaken only by registered dentist or the name of the company was amended so as not to include the word dental or dentist. So the applicants disagreed with the Register of Companies. So they went to court. They sought judicial review by way of mandamus to compel the registrar to register the company. And the court held that the registrar's refusal was unjustified. So the mandamus was granted. And the House of Lords, the court, which was presided by the Chief Justice at the time, Lord Reading, rendering his opinion, made the point that, in my opinion, the question turns in the main upon whether the use of these words, the United Dental Service, would amount to an offense under the Dentist Act 1878. I think these words, United Dental Service, imply a description of the acts to be performed and do not imply that the person who performed them are persons specially qualified under the Statute of 1878. So the Register of Companies will be entitled if the use of the proposed name will be an offense under the statute, either under this or any other statute, to refuse to register the companies with that name. But having arrived at the conclusion that that will not be the effect of the use of the words United Dental Service, I hold that the registrar was wrong in refusing registration upon that ground. So the court actually granted the mandamus to compel the registrar to register. Again, where the registrar is also capricious, and of course, you are mindful of our constitutional provision, Article 296 on discretionary power, as well as Article 23 on administrative justice. So where the registrar certainly has got discretionary powers, but the discretionary powers of the registrar is subject to judicial review, as it were. So again, the English case of R against Registrar of Company ex parte Attorney General, an incorporation by the registrar was quashed on the grounds of public policy. The registrar had actually exercised his power to incorporate, but the Attorney General actually challenged the incorporation of that company because, in his view, what the company was going to do was to facilitate prostitution, which was against public policy. In fact, if we look at the law report, the name of the company was Lindy St. Clair, into bracket, Personal Services Limited. And if you examine it closely, according to the Attorney General, they were going to promote prostitution, and that was the reason why he went to court for the court to quash the incorporation. Now, when the registrar is satisfied that all the necessary things have been done, then Section 14(1) of Act 992 requires that the registrar shall, after payment of the prescribed fee, certify under the seal of the registrar that the company is incorporated, and in the case of limited liability company, that the liability of the members is limited. So the company will have come legally into existence. Again, subsection 2 of section 14 provides that from the date of incorporation, the company becomes a body corporate by the name contained in the application for incorporation, and subject to section 13 is capable of performing the functions of an incorporated company. So the critical stage at which the company becomes a corporate person, a body corporate, is upon the issuance of the certificate of incorporation by the registrar. So as we have noted, a mere application for incorporation does not clothe the company with what? A corporate personality. But when the certificate has been issued, then the corporate personality is actually attained. So after the registrar certifies under his seal that the company is incorporated, a certificate of incorporation is issued to the company, and according to section 15 of Act 992, I'd like somebody to read that for us. Read section 15 for us. Section 15. Yes, Mr. Ade. Please read. Okay. I don't know if I've blocked the. Yeah.
Section 15. Good
Yes.
morning, my lord.
Yes, good morning.
Certificate of incorporation. Section 15. The certificate of incorporation or a copy of that certificate, certified as correct by the registrar, is conclusive evidence that the company has been duly incorporated under this act, and proceedings shall not be brought in a court to cancel or annul the incorporation.
Good. Attend. He used the word conclusive evidence as opposed to prima facie evidence. Prima facie evidence means that there can be a rebuttal, but conclusive evidence means that it's final. It does not matter whether a particular mistake was made, so long as the certificate has been issued. It is taken for granted that all that needs to be done for incorporation to occur have taken place, and that is why the registrar has certified that fact. And this is important because the lawmaker is trying to guard against the situation where a company is doing business, a company is running, and somebody will actually bring an action in court to try and have the company's incorporation cancelled or annulled, simply on the ground that wrong email address was provided, or there was a mistake in writing a telephone number, and for that matter, the incorporation certificate should not have been granted. So you want to guard against that to avoid the incorporation process being cautioned in law court. So if there was some technical defect or procedural omission or some description, that will not suffice, because there's a need to ensure commercial certainty and public confidence in registered companies. So just imagine if you are doing business with a company and you could not take for granted that its legal existence is actually sacrosanct, is guaranteed, and you just wake up and somebody has actually brought a case to try and say that certain steps were not properly done during the incorporation process, and for that matter, it should be cancelled. Imagine the kind of confusion that it will create. However, it does not preclude the institution of proceedings to wind up the company. So if you look at section 16, section 16 says that section 15 does not preclude the institution of proceedings to wind up the company in accordance with section 274. So if you go to section 274, it provides the most of winding up the company, of ending the company, and various modes are there. So we have the official liquidation, in which case you will now have to apply the Insolvency, Corporate Insolvency and Restructuring Act 2020, Act 1015, which deals with the framework for winding up and restructuring insolvent companies, or by private liquidation in accordance with Part V of Act 992. So those are different matters. So that one, if you are trying to wind up as under those regimes, is not really trying to question the processes of incorporation. So the processes of incorporation have been protected by the issuance of the certificate of incorporation, saying that all the necessary things have been done. So let's look at I told you should, apart from the Companies Act, you must also have the Insolvency and Restructuring Act. So let's look at this one, section 84. Section 84. Now the most of winding up. The official winding up of claim may commence by special resolution of the company, petition addressed to the registrar, petition to the court, conversion from private liquidation, or conversion for administration restructuring of the company. So section 81. And that's what we're interested in. We want to look at the section 84. Good. So if we look at section 84, somebody should read it for us. Somebody should read section 84 for us.
So I'm reading, Reverend Cancer.
Right.
So section 84, procedure on petition to the court. 84, section 1. The following persons may present a petition to the court for the official winding up of the company only on grounds specified in paragraph C, D, and E of subsection 2. A, the registrar. B, a creditor of the company. C, a member of a company with shares or contributory of the company. Or D, the Attorney General. So should I continue, sir?
Yes.
Section 2. The court may order the official winding up of a company on a petition presented where A, the company AI does not commence the business which the company is authorized by the constitution of the company to carry on, or II suspends business for a year within a year after the incorporation of the company. B, the company does not have members. C, the business or objects of the company are unlawful. D, the company is operated for an illegal purpose.
Good. So if you look at this, you notice that it's similar to the case law that we look at an English company law, where the Attorney General went to court to get orders to quash the registration of St. Clair, Lindy St. Clair Personal Services Limited, which was suspected to be using for prostitution, which is illegal. Look at the E to Jane. Yes, continue.
Yeah. E, the business being carried out by the company is not authorized by the constitution of the company. F, the company is unable to pay the debts of the company. Or G, the court is of the opinion that if it's just and equitable, that the company should be wound up.
Okay.
3.
It's okay. Thank you, Reverend.
Welcome, sir.
Okay, so now we have the company brought into existence as a corporate person. There are important legal effects or consequences attendant upon that. So first and foremost is the concept or the doctrine of separate legal personality. Separate legal personality. And that is to say that upon incorporation, the company becomes a corporate person, separate and distinct from its members and officers. So the company, in the eyes of the law, is seen as a person, although it does not have flesh and blood or leg and hands, But in the eyes of the law, it is seen as what? As a person, distinct from the members and the officers. So let's keep that in mind. And it's a very important and it's an elementary principle we should all appreciate as students of company law and future lawyers. So the company becomes an artificial person with legal capacity, and its rights and powers are different from that of its members. So you can read section 14.2 for us, and then another should read section 18 to drive home the point that upon incorporation, the company is actually a legal person in the sense that it can do things in its own right. Yes, section 14.2 and then 18. Yes. Is that there, Reverend? Are there? Yes, please.
Section 14.2 of Act 992. From the date of incorporation, the company becomes a body corporate by the name contained in the application for incorporation, and subject to Section 13, is capable of performing the function of an incorporated company.
Good. Good. So that is it. Then section 18.
Section 18(1). Subject to this Act and to any other enactment, a company shall have full capacity to carry on or undertake any business or activity, do any act or enter into any transaction, and b. full rights, powers, and privileges for the purposes of paragraph A. Without 18(2), without limiting subsection 1, and despite the provisions of any other enactment, a company shall be capable of giving and entering into and being bound by and claiming all rights under a deed or mortgage or other instrument.
All right. Good.
Okay.
Good. So you read those provisions in full on your own, but then they reinforce the point we have been laboring to make, that upon incorporation, the law treats the company as a legal person, artificial legal person. And that is why in Salomon and Salomon, Lord Magneton will make the point that the company is at law a different person altogether from the subscribers to the memorandum. And though it may be that after incorporation, the business is precisely the same as it was before, and the same persons are managers, and the same hands receive the profit, the company is not in law the agent of the subscribers or trustees for them, nor are the subscribers as members liable in any shape or form, except to the extent and in the manner provided by the Act. Now, this dictum of Lord Magneton is quite poignant in the sense that it strikes at the very heart of the concept of separate legal personality of the company. Yes, the subscribers certainly become like the members, but we are told that when the incorporation process has been concluded, and as we saw, the registrar has certified that fact and issued a certificate of incorporation, the members and then the managers or the officers, those who receive the profits of the company, they are not a principal or they are not agents. So the company is not an agent for those people. as it were. Neither is the company a trustee for them. No. And the company is an entity in its own right. And that is why the company can enter into transactions. It can incur legal liabilities. It can also acquire rights and pursue its rights when they are violated. No, a similar point was made essentially in Moko versus Kuma. But before we leave here, I ask you to read the case of Salomon and Solomon. You have not demonstrated that you have read it. So we are going to talk about that and that we discuss that case in full to end the class, and then we continue next time. So Salomon and Solomon, what happened? The basic facts were that Mr. Salomon was a wealthy man as far back as 1892 because he was a boot and a shoe manufacturer trading on his own sole account, like sole proprietorship, under the name A. Salomon and Co. Despite the fact that he was trading under the name A. Salomon and Co., he was still a sole proprietor. And he traded at the High Street, Whitechapel area. And there, he had extensive warehouse and a large establishment. And the case report indicates that Mr. Solomon had been in trade over 30 years at the same location. So he had lived in the same neighborhood all along. And for many years past, Mr. Solomon had occupied the same premises. So far, things had gone very well with him. He began with very little or no capital, and he gradually built a thriving business. And people respected him and could do business with him even on credit. Now, Mr. Solomon is said to have had the potential of maybe selling his business for not less than £10,000 if he really wanted to, but that had not been done. He had a wife and 5 sons and a daughter. 4 of the sons were working with their father, but the sons were not partners. They were only servants. They were dissatisfied with their position, so they kept pressing their father, Mr. Solomon, to give them a share in his business. So during the trial, Mr. Solomon said that they troubled me all the while. So at length, Mr. Solomon did what hundreds of others have done under similar circumstances. he turned his business into a limited company. And he wanted to extend the business and make provision for his family. So his motive was just to expand the business and also make his family happy, as it were, not for any evil purpose, as you can see. So Mr. Solomon went through all the usual formalities for registering a company under the then legislation, Companies Act 1862. There was a contract with the trustee in the usual form for the sale of the business to a company about to be formed. So now, to enable his private sole proprietorship transition seamlessly to the new company, he sort of created like a trustee and have the business, if you like, to be roughly been valued as it will. And there was a memorandum of association, that is the constitution of the company, duly signed and registered. And it stated that the company was formed to carry that contract into effect. What contract? That is the contract for the sale of the business which Mr. Solomon was running as a sole proprietor. And it fixed the capital of the company as £40,000 in 40,000 shares of £1 each. Then he also had his usual articles of association, which provided the machinery for running the business. So his company was intended to be a private company, and it remained that to the end. No invitation was made to the public, and the subscribers to the memorandum, that is the constitution of the company, were Mr. Solomon, his wife, and 5 of his children, who were grown up then. So the subscribers met and appointed Mr. Solomon and his 2 elder sons as directors. And then the directors then proceeded to carry out the proposed transfer of the business from Mr. Solomon's previous sole proprietorship to the new company. So the price fixed by the contract was duly paid to Mr. Solomon. And on paper, the price fixed amounted to over £39,000. So the purchase money was paid in a very interesting way. As and when money came in, sums amounting to £20,000 were paid to Mr. Solomon, and then immediately returned to the company in exchange for fully paid shares. Very interesting. Then the sum of £10,000, which Mr. Solomon seems to have received and retained, £10,000, which was left, was actually paid in debentures. That is it's like a permanent loan which Mr. Solomon had put in the business. And the balance, with the exception of about £1,000, which Mr. Solomon seems to have received and retained, went in discharge of the debts and liability of the businesses at the time of the transfer. Mr. Salomon received for his business about £1,000 in cash, 10,000 in debentures, and half the nominal capital of the company in fully paid shares. No other shares were issued except 7 shares, taking one for the wife and one for each of the 6 children. The company fell upon evil days because there had been great depression in the boot and shoe trade. There were strikes of workers, and in view of that danger, contrast the public bodies, which were the principal source of Mr. Solomon's profit, were split and divided between different firms. So attempts were made to push the business on behalf of the new company, cram its warehouses with unsellable stock. Mr. Solomon seems to have done what he could. Both he and his wife lent the company money. So look at it. They are members and directors, but they are lending money to the company. Because we know the company is a separate legal person. And Mr. Solomon got his debentures cancelled. So he cancelled his £10,000 debentures. And he reissued to Mr. Broderick, who advanced him £5,000, which he immediately handed over to the company on a loan. Then Mr. Solomon gave it to the company on a loan. Now, this was a temporary relief, and it only worsened things later on. Mr. Broderick's interest was not paid. He has given a loan to the company, but his interest was not paid when he became due. So he decided to sue at once. And when he sued, he got a receiver appointed. And then liquidation came. And there was a forced sale of the assets of the company. They realized enough to pay Mr. Broderick, but not enough to pay debentures in full, and unsecured creditors were consequently left out in the cold. So in this state of things, the liquidator who had been appointed to oversee the closing down of the company and paying of creditors met Mr. Broderick, who had made a claim. So the liquidator also made a counterclaim in the suit which Mr. Broderick had brought against the company and the liquidator. Now, Mr. Solomon was made a defender to that suit, which Mr. Broderick had actually brought against the company. He disputed the validity of the debentures. Now, Mr. Broderick argued that the debentures Mr. Solomon was claiming he had in the company was not valid because it was fraudulent. And for that matter, he wanted rescission of the agreement for the transfer of the business and then cancellation of the debenture. So the agreement which was made to transfer the business from Mr. Solomon's old sole proprietor business ship to the new company, in Mr. Broderick's view, the whole arrangement was quite fraudulent, so the court should actually disregard it, and consequential orders cancelling the benches and everything made as part of that arrangement. And repayment by Mr. Salomon of the balance of the purchase money. Or in the alternative, Mr. Broderick claimed payment of £20,000 on Mr. Solomon's shares, because in his view, nothing had been paid on the 20,000 shares, which were standing in the name of Mr. Salomon as his shares in the company. So he wanted the court to push him to pay the 20,000 shares. So this matter came on trial before Van Williams J. The validity of Mr. Broderick's claim was admitted. So the court agreed with the claim which Mr. Broderick was making against Salomon and also his company. And it was not disputed that the 20,000 shares were fully paid up. So that did not actually form part of the dispute. And the case presented by the liquidator broke down completely. But the judge suggested that the company had a right of indemnity against Mr. Solomon. So the company can sue Mr. Solomon. The signatories of the memorandum of association were, the judge said, mere nominees of Mr. Solomon. That's the trial judge. That they were mere dummies. That was the expression he used. So the company was Mr. Solomon in another form. He used the name of the company as an alias. He employed the company as his agent. So the company he thought was entitled to indemnity against his principal. And the counterclaim was amended to raise this point. And when the amendment was made, the trial judge pronounced an order in accordance with the view he had expressed. So ruled in favor of Mr. Broderick. And this eventually came on appeal. It came eventually on appeal right up to the House of Laws. And I would like you to read the full judgment. I'm just taking my time to narrate as much of the facts as possible. Because when I asked you to go and read, you didn't read. Now, Lord Magneton in his opinion, contributing to the decision of the House of Laws, would observe that, among other things, that among the principal reasons which induce persons to form private companies, as stated very clearly by Mr. Palmer in his treatise on the subject, are the desires to avoid the risk of bankruptcy and the increased facility afforded for borrowing money. I'm quoting from Lord Magneton's opinion. By means of a private company, as Mr. Palmer observes, a trade can be carried on with limited liability and without exposing the person's interests in it in event of failure to the harsh provisions of bankruptcy law. A company too can raise money on debentures, which an ordinary trader cannot do. Any member of a company acting in good faith is as much entitled to take and hold the company's debentures as any outside creditor. Every creditor is entitled to get and to hold the best security the law allows him to take. If, however, the declaration of the Court of Appeal means that Mr. Solomon acted fraudulently or dishonestly, I must say I can find nothing in the evidence to support such an imputation. The purpose for which Mr. Solomon and the other subscribers to the memorandum were associated was lawful. The fact that Mr. Solomon raised £5,000 for the company on the debentures that belonged to him seems to me strong evidence of his good faith and of his confidence in the company. The unsecured creditors of A. Solomon & Co. Limited may be entitled to sympathy, but they have only themselves to blame for their misfortunes. He trusted the company, I suppose, because they had long dealt with Mr. Solomon, and he had always paid his way, but they had full notice that they were no longer dealing with an individual. Lord Magnetic continues. It has become the fashion to call companies of this class one-man companies. That is a taken nickname, but it does not help one much in the way of argument. If it is intended to convey the meaning that a company which is under the absolute control of one person is not a company legally incorporated, although the requirements of Act of 1862 may have been complied with, it is inaccurate and misleading. If it merely means that there is a predominant partner possessing an overwhelming influence and entitled practically to the whole of the profit, there is nothing in that I can see contrary to the true intention of the Companies Act or against public policy or detrimental to the interest of creditors. If the shares are fully paid, it cannot matter whether they are in the hands of one or many. If the shares are not fully paid, it is as easy to gauge the solvency of an individual as to estimate the financial ability of a crowd. One argument was addressed to your lordship, which ought perhaps to be noticed, although it was not the ground of decision either of the courts below. It was argued that the agreement for the transfer of the business to the company ought to be set aside because there was no independent board of directors, and the property was transferred at an overvalue. There are, it seems to me, two answers to that argument. In the first place, the directors did just what they were authorized to do by the Memorandum of Association. There was no fraud or misrepresentation, and there was nobody deceived. In the second place, the company have put it out of their power to restore the property which was transferred to them. Now, Lord Hosbris, the Lord Chancellor, also has this to say. The important question in this case, I'm not certain it's not the only question, is whether a respondent company was a company at all. Whether in truth that artificial creation of the legislature has been validly constituted in this instance. And in order to determine that question, it is necessary to look at what the statute itself has determined in that respect. I have no right to add to the requirements of the statute or to take from the requirements that's enacted. The sole guide must be the statute itself. Now, that there were 7 actual living persons who held shares in the company has not been doubted. As to the proportionate amounts held by each, I will deal presently, but it is important to observe that this first condition of the statute is satisfied, and it follows as a consequence that it will not be competent to anyone, and certainly not to these persons themselves, to deny that they were shareholders. I must pause here to point out that The statute enacts nothing. So what I'm doing is actually your punishment for not reading the case. So I'm virtually reading the judgment with you. I must pause here to point out that the statute enacts, no, sorry. I must pause here to point out that the statute enacts nothing as to the extent or degree of interest, which may be held by each of the serving, as to the proportion of interest or influence possessed by one or the majority of the shareholders over the others. One share is enough. Still less is it possible to contend that the motive of becoming shareholders or of making them shareholders is a field of inquiry which the statute itself recognizes as legitimate. If they are shareholders for all purposes. And even if the statute was silent as to the recognition of trusts, I should be prepared to hold that if 6 of them were trustees for the 7, whatever might be their rights inter se, the statute would have made them shareholders to all intents and purposes, their respective rights and liabilities. And dealing with them in their relation to the company, the only relations which I believe in law will sanction will be that if there were corporations of the corporate body. I am simply dealing with the provision of the statute, and it seems to me to be essential to the artificial creation that the law should recognize only that artificial existence, quite apart from the motives or the conduct of individual corporators. So it's saying that the motives for registering the company is not important when we are talking about the legal existence of the company. In saying this, I do not at all mean to suggest that if it could be established that this provision of the statute to which I'm adverting had not been complied with, you could not go behind the certificate of incorporation to show that a fraud had been committed upon the officer entrusted with the duty of giving a certificate, and that by some proceeding in the nature of certifies, you could not prove the fact that the company had no real legal existence. But short of such proof, it seems to me possible to dispute that once the company is legally incorporated, it must be treated like any other independent person with its rights and liabilities appropriate to itself, and that the motives of those who took part in the promotion of the company are absolutely irrelevant in discussing what those rights and liabilities are. And this is the crux of the matter. I repeat this dictum of Lord Hosbury in the Salomon and Salomon. But short of such proof, it seems to me impossible to dispute that once the company is legally incorporated, it must be treated like any other independent person with its rights and liabilities appropriate to itself, and that the motives of those who took part in the promotion of the company are absolutely irrelevant in discussing what those rights and liabilities are. I will, for the sake of argument, His Lordship continue. I will, for the sake of argument, assume the proposition that the Court of Appeal lays down that the formation of the company was a mere scheme to enable Aaron Salomon to carry on business in the name of the company. I am wholly unable to follow the proposition that this was contrary to the true intent and meaning of the Companies Act. I can only find the true intent and meaning of the Act from the Act itself, and the Act appears to me to give a company a legal existence with, as I have said, rights and liabilities of its own, whatever may have been the ideas or schemes of those who brought it into existence. I observe that the learned judge von William J. held that the business was Mr. Solomon's business and no one else, and that he chose to employ as agent a limited company, and he proceeded to argue that he was employing that limited company as agent, and that he was bound to indemnify that agent, the company. I confess, it seems to me that that very learned judge becomes involved by this argument in a very singular contradiction. Either the company was a legal entity or it was not. The business belonged to it and not Mr. Solomon. If it was not, there was no person and no thing to be an agent at all. And it is impossible to say at the same time that there is a company and there is not. Lindy LJ, on the other hand, affirms that there were 7 members of the company, but he says it is manifest that 6 of them were members simply in order to enable 7th himself to carry on a business with limited liability. The object of the whole arrangement is to do the very thing which the legislature intended not to be done. It is obvious to inquire where the intention of the legislature manifested in the statute is, even if we are at liberty to insert words to manifest that intention. I should have great difficulty in ascertaining what the exact intention thus imputed to the legislature is or was. In this particular case, it is the members of one family that represent all the shares. But if the supposed intention is not limited to so narrow a proposition as this, that the 7 shareholders must not be members of one family, to what extent may influence, authority, or intentional purchase of a majority among the shareholders be carried so as to bring it within the supposed prohibition? It is, of course, easy to say that it was contrary to the intention of the legislature, a proposition which by reason of its generality it is difficult to bring to the test. But when one seeks to put as an affirmative proposition what the thing is, what the legislature has prohibited, there, as it appears to me, insuperable difficulty in the way of those who seek to insert by construction such a prohibition into the statute. As one mode of testing the proposition, it will be pertinent to ask whether 2 or 3, or indeed all 7, may constitute the whole of the shareholders, whether they must be all independent of each other in the sense of each having independent beneficial interests, and this is a question that cannot be answered by the reply that it is a matter of degree. If the legislature intended to prohibit something, you ought to know what that something is. All it has said is that one share is sufficient to constitute a shareholder, though the shares may be 100,000 in number. Where am I to get them from the statute itself, a limitation of that provision, that the shareholder must be an independent and beneficially interested person? My lords, the learned judges appear to me not to have been absolutely certain in their own minds whether to treat the company as a rare thing or not. If it was a rare thing, if it had a legal existence, and if consequently the law attributed to it certain rights and liabilities in its constitution as a company, it appears to me to follow as a consequence that it is impossible to deny the validity of the transaction into which it has entered, unquote. Yeah, so the takeaway from Solomon and Solomon, as I have be at pains to virtually read significant portions of the judgments we do, is to drive home the point that once you have complied with the procedure for registration and the registrar has certified that you are properly incorporated, you acquired the legal personality and you have the legal capacity to acquire rights, incur liabilities, and so on and so forth. And I urge you to read Moko and Kuma, in which Sophia Kufu JSC actually then was made a similar point. So I'll draw the curtain here, and I will send you continuation of this lecture for you to also listen to, so that we can quickly move on to other areas at our next time. If there are any questions, I will take them before we end. Yes, entry manual. Let me stop the record.
Yes, sir.